Today I want to change some of the guidance I've been giving out in some of my videos about filing the I-90 to renew your green card. So sometimes permanent residents spend way too much time outside of the United States. And by the way, sometimes people have really old green cards that don't even have an expiration date. And the general guidance has been, like, if you use that green card to re-enter the US, you shouldn't have problems filing the I-90. The government pretty much just hands out the replacement green card. They don't really check your criminal history. When they do that, they don't really check anything. They kind of just check to see if you show up in their system as a permanent resident, and then they renew your green card. Well, it appears that the good times are over. I recently consulted with somebody who spent a fair amount of time outside of the US. She has been traveling back and forth every 6 months, but most of her time was actually spent outside of the United States. And she just filed to renew her I-90, and this is what USCIS said. They issued a request for evidence saying, USCIS records indicate that you have departed the US since August 15th, 2024. By the way, when they issued this, it had not yet been 6 months from August 15th, 2024. I don't know when you're watching this video, but within 6 months, she filed this I-90. So our records indicate you've been out of the US since August 15th, 2024, after you were granted lawful permanent resident status. Extended absence from the US is evidence that a lawful permanent resident has abandoned their lawful permanent resident status and is no longer a lawful permanent resident. Please provide the following information. And then there are 5 bullet points. 1, a detailed history of your travel outside of the US since 2014, when you became a permanent resident. So she has been a permanent resident for 10 years, but lately she's been spending a ton of time outside of the US. Most of her time, in fact. Photocopies of your passports issued since 2014. These copies should include all pages with stamps showing your entries and exits from the United States since 2014. That suggests that USCIS has really incomplete records, which is pretty on point, because for permanent residents, if you go onto the I-94 CBP website and you look at your travel history, you'll see that the information about your entries and departures from the US is really incomplete. A written statement detailing your residence since 2014. Please explain any periods of residence outside of the United States. That statement can create real problems, because now USCIS is putting you in a position where they clearly don't have all the records. Otherwise, they would have just denied this. Now they want you to lock yourself into some statements. And at that point, I would speak to an attorney. Evidence to establish your residence and employment history since 2014. Such evidence should include, but is not limited to, pay stubs, US tax returns, utility bills, deeds, mortgages, and leases. And 5, your date of return to the United States. She was actually filing this I-90 from outside of the US, so she hadn't even returned yet. So she received this request for evidence, and basically where we are now is I'm waiting for her to write a detailed statement, and we're gonna work on it and edit it to make sure it satisfies USCIS. I also said, independently of this RFE, you should immediately hop on a plane and come back to the US, because completely separate from this issue, you are at real risk of losing your residency in the very near future. And if you don't have problems in the airport, you should immediately apply for a re-entry permit, so that, if you want to continue residing abroad, at least 2 years from now, you'll have a legal way to re-enter the US. For those of you who don't know, a re-entry permit is filed on Form I-131, and it's a way for permanent residents to just have a long extended absence outside of the US for up to 2 years. And by the way, after the 2 years, you can apply for a new one, but there are limits, and you won't face losing your green card by spending too much time outside of the US, as long as you are within the re-entry permit's 2-year period. Also, a side note, during these 2 years, you can still travel back and forth to the US, but customs isn't going to give you a hard time about your extended absence during the 2-year re-entry period. After we talked about that, we talked about what should she do if she's presented with the I-407, the voluntary abandonment of residency form in the airport. I think there's a very high probability that when she re-enters, the customs officers in the airport are gonna say like, hey, we don't believe you're actually living in the US permanently, which is a violation of the terms of your permanent resident status. We want you to sign this form to formally, voluntarily abandon your permanent residence. And she could always say, no, I don't want to sign that. But if she says no, there's a very high probability that they will process her and give her a notice to appear, in NTA, in immigration court. And once an NTA has been issued, you can't really freely travel in and out of the US because you have an ongoing removal proceedings, in deportation proceedings. And at that point, you really need to stay in the US continuously until those immigration court proceedings have been fully resolved, which could, at the bare minimum, take 6 months, but I've never actually seen it resolve that quickly. More realistically, it's probably gonna take like 1 to 2 years or 1 to 4 years before that's processed. So if she enters and she is presented with the I-407 and she refuses to sign it, she would pretty much have to stay in the US continuously. And she told me like, I can't. My life right now is pretty much outside of the United States. I do want to reside in the US, but I have all these ongoing obligations right now. And it turns out they were circumstances that were outside of her control. And she actually had been permanently residing in the US during that time. So it was kind of a gray area whether or not she was able to meet her burden of proving that she's really intending to be a permanent resident, or whether she's intending to reside abroad right now. Because I'll give you an example. If you're a permanent resident of the US and you're attending college abroad, you might spend 90% of your time for a couple years outside of the US. But generally speaking, customs officers will take the position that you're still a permanent resident, you're permanently living in the US, and you have a temporary residence abroad and a good reason for temporarily residing abroad. And that was actually one of the circumstances that she was dealing with at that time, and some other personal family stuff. In most of the videos where I talk about permanent residents entering, I pretty much in all of them say, don't sign the I-407 until you speak with an attorney. Well, she spoke with an attorney, she spoke with me, and we ultimately decided like, look, if they're gonna try to get you to sign the I-407, and it's either that or removal proceedings, I would probably rather you sign the I-407 than be placed into removal proceedings and have to leave the US a month or two later and get a removal order. Because once you get a removal order, which is also known as a deportation order, it's gonna be a nightmare to fix that. If you have a pathway to come back, like a US citizen family member who can petition for you in the future, signing the I-407 might be the lesser of the two evils when you're presented with those two pretty terrible options. So in this case, I believe when she re-enters the US, if she has to deal with that, terrible choice, she'll probably end up signing the I-407 because it'll be the easiest route for her to re-enter the US in the future. Now, if she decides not to sign the 407 and she gets a notice to appear in immigration court, I actually think she has a fair probability of decent chance of winning her case in front of an immigration judge and being able to keep her permanent residence. But if she has to leave before her first court date or something like that, she'll be in a worse situation in this particular case than she would have been if she just signed the I-407. All right, guys, so that brings us to the end of today's video. I just wanted to give you guys an update on how USCIS is using the I-90 now to challenge whether or not people actually are permanent residents. I've never seen anything happen like this before. As I receive more updates and deal with more clients who are in situations like this, and this case is actually still pending, it's still ongoing and hasn't been fully resolved. So once there's an update on this, I'll be sure to make another video. If you're interested in content like this, be sure to subscribe. If you need assistance with any immigration matter, my information is in the video description below. I would love to consult with you and either give you all the information you need during the consultation, or if you require more assistance and you need an attorney to represent you, I would be happy to do that as well. Thanks for watching, and I'll see you guys next time for another video.